welcome to the deep dive. Our mission is pretty simple. Cut through the jargon, get straight to the core knowledge you need from, well, sometimes pretty dense topics. Think of us as your guide to really grasping what matters.
Exactly. And today we're really getting into the weeds of U.S. patent law. We're looking at Chapter 2100 of the MPP, the Manual of Patent Examining Procedure.
MPP 2100. Yeah.
And specifically, Section 2150. This one's really foundational stuff.
Right, Section 2150. That sounds familiar. That's where the USPTO, the Patent Office, spells out how they decide if something's actually patentable under the current rules, the first-to-file system.
Got it.
Feels like ground zero for anyone studying for the patent bar or even just trying to navigate patent applications.
Absolutely. Today's deep dive is all about getting a handle on the examination guidelines for patentability, specifically under the First Inventor to File or FITF provisions.
Which came in with the AIA, the American Invents Act.
Correct. It's like essential knowledge if you're prepping for the patent bar or just dealing with patent prosecution day to day.
Because it wasn't always this way, was it? We had that whole first to invent thing going on for ages. That shift to first to file, that was a pretty big deal. When did that actually happen?
Yeah, huge shift. The key date you need to remember is March 16th, 2013. That's when first to file officially took over as the standard.
March 16th, 2013. Got it.
So in this deep dive, we'll clarify how the USPTO looks at what's called prior art. The existing knowledge out there under the revised Section 102 of the patent law. And crucially, we'll also talk about why the old rules, the pre-AIA rules, are still really important to understand.
Okay, so the world before March 2013 hasn't just, vanished from patent law.
Not at all. Section 2150 actually gives the guidelines for examiners for both the AIA versions of Sections 102 and 103 and their pre-AIA versions. The trick is figuring out which set of rules the examiner needs to apply to any given application.
Okay, so how do you figure that out? What's the magic formula? AIA rules or pre-AIA rules?
Well, generally speaking, if an application was filed on or after March 16, 2013, it gets examined under the AIA rules. Pretty straightforward.
Generally speaking.
Right. But here's the key thing. Applications filed before that date, they usually keep their pre-AIA status.
Usually. So there's a catch.
There is. The big exception is if that older pre-AIA application at any point included even one claim that has an effective filing date on or after March 16th, 2013.
Oh.
Or if it claims priority to or the benefit of a later application that was filed on or after that date. That's the trigger.
That's a very specific trigger. So just because an older application has some procedural stuff happen after March 2013, that doesn't automatically flip it into the AIA category.
Exactly right. So for instance, let's say you file an RCE, a request for continued examination on an old application, but you file it after March 16, 2013. That action by itself doesn't make it an AIA application. Same thing if you enter the national stage here in the U.S. from an international application after that date, under 35 U.S.C. 371, or even if you add new matter through amendments after March 16th, 2013, none of those things on their own convert the application status.
What about those international applications, the PCT ones? If they were filed before the deadline, they always seem to add a wrinkle.
They can, yeah. For PCT applications filed before March 16th, 2013, their status AIA or pre-AIA really hinges on the claims again. Did they, at some point later, include a claim that has an effective filing date on or after that critical March 16th date?
So it always comes back to the claim's effective filing dates.
Pretty much. That's the deciding factor for whether the whole application gets pulled into the AIA framework.
Okay, now what if you add new claims to an older pre-AIA application? But these new claims clearly have a filing date after March 16, 2013. What happens then?
Yeah, this is where it gets really interesting and potentially tricky. If you introduce just one new claim into a pre-AIA application, and that claim's effective filing date is on or after March 16, 2013.
Then the whole thing flips.
The entire application becomes subject to the AIA provisions. Boom. It's a really crucial point. It can totally change the game for how prior art is applied against your invention.
Wow. Okay. So definitely something to watch out for. All right. So we've kind of nailed down when the AIA rules apply. Let's talk about how prior art gets evaluated under the AIA's Section 102. What's the big difference compared to the old first to invent way?
Well, the fundamental shift, like we said, is first to file. Under the AIA, it's basically whoever gets their application filed first generally gets priority.
Right.
That's a major departure from pre-AIA, where the whole focus was on proving who actually invented the thing first, even if they filed later. MPP Section 2150 gives examiners the specific roadmap on how to apply this revised Section 102 when they're looking for prior art.
So it's less about that eureka moment and more about winning the race to the patent office door.
That's basically the core idea, but it's not quite that simple. The AIA does have some important exceptions to what counts as prior art.
Exceptions,
Yeah.
like what?
They're laid out in Section 102B to these cover situations like the inventor's own earlier work or disclosures, or someone else publicly disclosed something they got from the inventor, and also subject matter that was commonly owned with the invention being claimed.
Common ownership. Okay, that rings a bell from the old pre-AIA rules, too. Section 103C, right?
It should, yeah. Pre-AIA 103C did deal with common ownership, but how it works under the AIA is, well, significantly different.
How so?
MPP Section 2154.02b gets into the nitty-gritty, but basically the AIA has specific conditions, like how the commonly owned prior art had to be derived from the inventor or joint inventor. It's not just about ownership anymore.
Got it. So even in this first-to-file world, there are still ways an inventor's own work, or work done within the same company maybe, might not block their patent. Okay, what about obviousness? Section 103, how's that handled under the AIA?
Right, obviousness. Still under 35 U.S.C. Section 103, but the analysis is directly tied to the new definition of prior art in AIA Section 102. So the very first thing an examiner has to do before even thinking about obviousness is figure out, are we applying pre-AIA law or AIA law to this application?
Because that determines what counts as prior art for the obviousness test.
Exactly. That initial decision dictates which version of Section 102 defines the prior art, and then which version of Section 103 they use to see if the invention would have been obvious. Obvious to someone skilled in the art, either at the time of invention for pre-AIA or before the effective filing date for AIA.
So the whole obviousness analysis hinges on getting that AIA versus pre-AIA determination right first.
Precisely. And the MPT directs them where to look. If it's pre-AIA law, examiners use MPP sections 2131 through 2138 for guidance on obviousness.
Okay.
If it's an AIA application, they jump forward to MPP section 2159 and the sections after that. Those specifically explain obviousness in light of the AIA's definition of prior art.
And the MPP provided standard language for these rejections too, right? Those form paragraphs.
Yes, exactly. For AIA rejections under Section 102, they'll use paragraphs like 7.03.ai, 7.07.ai, 7.15.ai. There's also one 8.32.ai for provisional rejections over applications that are still pending.
The .ai tells you it's for AIA cases.
Correct. Crucially, those are only for applications filed on or after March 16th, 2013.
And for the older pre-AIA ones, different paragraphs.
Yep. For a pre-AIA obviousness rejection under 103A, especially if the prior art is based on Section 102, F, or G, dealing with prior invention by someone else, the examiner would use form paragraph 7.21.ftf.
FTI for first to invent, I guess.
Makes sense. And another point here, if an examiner made a provisional rejection under pre-AIA 102E 103A, but the reference turns out to be disqualified because of that pre-AIA 103C common ownership rule we mentioned.
They have to withdraw that rejection.
They shouldn't maintain it, no. The common ownership disqualifies the reference under those specific circumstances.
It really does paint a picture of Section 2150 being this central junction box in the MPP, directing traffic for both the old and new patentability rules.
That's a good way to put it. Section 2150, working together with all those other MPP sections we've mentioned, really provides the roadmap. It's meant to ensure examiners apply the law consistently, whether they're looking at a pre-AIA application or an AIA one.
Consistency and predictability, that's the goal.
Right. For examiners and, just as importantly, for you, the applicant or practitioner navigating the system.
Okay, so let's quickly recap the big takeaways for you listening. That filing date, March 16th, 2013, is paramount. And whether any claim ever got an effective filing date on or after that point, that's what decides. AIA first-to-file rules or pre-AIA first-to-invent rules.
Absolutely. And understanding that difference is just, well, fundamental if you're working in this field or studying for the bar. It dictates everything about prior art under Section 102 and obviousness under Section 103.
Getting it right affects the whole examination process.
And ultimately, whether you get a patent and how strong that patent is.
This has been really clarifying. It's such a core part of the current system. Final thought for you, the listener. How do you think this big shift to first-to-file has actually changed how companies or inventors approach innovation itself? Is there more pressure now to file fast?
Does it change R&D timelines, disclosure strategies?
Yeah, what are the sort of downstream effects of changing such a fundamental patent law principle? Definitely some food for thought there.
And we really do encourage you, if this is relevant to your work or studies, dive into MPP Section 2150 itself and the other sections we touched on. Reading the source material gives you that deeper layer of understanding.
Absolutely. And before we wrap up, a special thank you is definitely in order to Mike Shepard. He's the creative director who really organized this whole MPP audio series project.
Yeah, his dedication was key in turning this, let's be honest, pretty dense legal text into something much more accessible for everyone.
Agreed. It's a fantastic resource.
And one final important note. Please remember this summary was generated using AI tools like ChatGPT and NotebookLM. While we've aimed for accuracy, it might contain errors or omissions.
Right. This is for educational and informational purposes only. It is definitely not legal advice. For any specific situation, you really need to consult the official MPP documents, talk to a qualified instructor, or get advice from a registered patent practitioner.
Always go to the official source or a qualified professional for definitive guidance.